yo.
Yes, sir.
What's up, guys? Yes. This DJ will kick the floor in 3, 2, 1.
On the troll.
Hello and welcome back to ZUNGU. We're back. Yeah, we have been away. I have been away. So we could not continue as we would have liked. It was impossible. The things were not allowing. We are not at that level of being able to travel with some of the equipment on the other side and be able to connect freely and willy-nilly. So we so far require the studio to work. But we are here for continued purposes and we're going to deliver. This is probably a surprise to you. We could have done it yesterday, but believe in you me, I had not watched anything because where I was, it was, the deepest of the deepest when you talk about the rural areas. So it is really hard to even get a gig and to have it working fully without any disturbance. But we are here. That's part of South Africa, by the way. I was not in Lesotho, I was not in Botswana, I was not anywhere else. I was in South Africa, where I was born. Still my place. I love it so much. Peaceful, no disturbances when you are there and you are on leave. No one disturbs you. No one can find you unless you want them to find you. And I'm back now. My leave was cut short. Oh, well, I'm still on leave, technically, on the other side. But here, my leave is done. Greetings to you, Emily. How are you doing?
I'm okay.
I'm sure now you have settled down. I mean, the last time you called me when I was at home, you were fuming. You were so angry.
I was.
You couldn't even explain yourself. But I had some RATHA there. I had a lot of what in the hell. But upon watching it today, I understand why you were at that point. There are a lot of things that does not make sense. Right. So let us hear what that thing is. Just greet, and then for now, please, for subscribers, come in, like the video as usual, and then let the morning gang do their job. But for the night riders, it's too early for you. I'm sure there's even morning gang here. So please make sure you leave your mark, like the video, keep commenting, subscribe, become a member, do it all. Do it all if you can, and we appreciate that. We love you for that, because we don't need to remind you that much to like the video, which does not take anything, just takes a bit of your second away from listening, maybe, if you cannot multitask. Greetings to you, all of you. Emily, the floor is yours.
Hi guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us yet again for another live stream. I know we are 2 days late, but I couldn't go live by myself. Okay, I can't do it. It's too much admin that is going on. So Mr. Anonymous is not around.
Not that you cannot do it, Emily. Not that you cannot. You can do it actually. Going live is not just a list of your problem. Like going
for me, it's too much admin.
It's admin of the systems. Yes.
And provided that I still have to prepare. So usually I'm wishy-washy before going in front of the camera. I prefer someone else to do it. I don't know if it makes sense, because the June, Julys that I get, the anxiety I get, I just want to focus on delivering a show.
Yes,
I can't deal with the technical stuff, the camera, the in everything, the buttons. There's so many. They just make me freak out. So I tried, but then I was like, this is
So
too
maybe
much.
that's why then we beg from membership increment so that we can get a guy that can be a body here. Maybe be able to pay a stipend to that person so that when I'm not there,
that can handle the
Yes.
technicalities, so that I focus on crafting the content, because that's what I am good at and that's what I like to do. And it's not that I'm limiting myself, but at the same time, before just going
overwhelming.
live, just before you see that moment before, it's like a lot is on my mind. I'm thinking, what are people going to
Z
say?
is taking an offense when I said I was not in Lesotho. No, man, Z, you don't get me. I'm sure you guys have. What is that internet that they are busy trying to?
Starlink.
Yeah, I'm sure you have even Starlink that side. I was just saying that no, there are places in South Africa, a lot of them, where we
still don't
still
have
are off
Internet.
all these other
access.
things except for electricity. Even water, you still have to walk a distance, even though it comes from the tap and it comes from underground, but the taps are not inside our homes. That's my place. So Lesotho, I was just making an example that, other people might think, he was outside the country. I'm not outside the country. I was not outside. I was at home. I was just in my own corner there, enjoying the life out of those people
Smelling
who,
fresh green.
when they
air.
get any chance that they get, they ask for a bottle of beer anytime, where you need to be able to give it to them every day. Very nice feeling. All days, just rolling back the years, which I enjoy the most. I think when I retire, I will go to villages.
You think?
Definitely. Yeah, it's peaceful, except for witchcraft. Okay. Let's continue. And we will soldier on. Let's continue then.
Yo, guys, I was filming on Tuesday. I was very upset. Okay, and I didn't know what to do with myself, because I kept thinking to myself, what is going on? What is going on in this country? I heard a judge testify as a character witness of a witness, speaking on their behavior and their state of mind. It was very satiric. What ZUNGU said was very satiric. I'm like, Haibo, what is going on? It was very satiric.
I really enjoyed listening to RATHA for some weird reason. You know why?
Why?
Because there are people who still think that RATHA will come back and
be fair.
give a fair judgment, in my opinion.
And there's also those attacks. Where are those people that kept saying, hey, the judge, take it easy on the judge? Do you still think that we must take it easy?
Yeah, basically, they were able to suss out what actually is going to be said. And clearly, you saw it. Upon fighting for DNA, which eventually we won, because it was not mentioned there.
The inconclusive
Listening
DNA.
to all that gibberish, but let us be happy for one thing, that DNA did not stand.
No, the DNA did not stand.
That DNA.
It did not stand. And what else? Makaleni, who was trying to sneak in Makaleni's evidence. It also didn't make it to his judgment.
So we have an idea of what to expect and what you need to debunk. But doesn't mean that if you debunk it, even with enough evidence, it does not mean that you are off the hook. Judging from what we had, judging from what we had,
He
and
found
the
other things.
the things being made up, if you ask me, it does not mean that you are off the hook. You just are doing the job for your customer, which is what you were hired to do. But it does not exonerate your client. So please, it was good for me to just
He was
hear.
like a prosecutor showing Advocate Baloyi and Sibanda how it's done. I've never seen anything like that in my life. I'm so traumatized. But we're going to go through the judgment because that's how we roll here on Mzansi Reality. We're going to show you why this judgment was so problematic. We're going to take it step by step like we usually do. And I'm going to start at the beginning because on Tuesday, court started with Advocate Baloyi apologizing for the late start. So Judge RATHA Mokgwatleng now started pending his judgment in the application brought by Advocate Nxumalo on behalf of accused number 4, Mr. Mapisa, pursuant in application in terms of Section 174. He started by explaining Section 174, and he said that if at the close of the prosecution at any trial, the court is of opinion that there is no evidence that the accused committed the offense referred to in charge of any offense of which he may be convicted on the charge, it may return a verdict of not guilty.
Which is not something new.
Yeah.
If you were here at Mzansi Reality, we already discussed that, right?
We did. So the question whether a court should grant a discharge at the stage of the proceedings, that means at that stage where the state has closed its case, is one which has entailed a lot of debate and also entails that the court use a judicial discretion in arriving at the vexed solution. He also quoted the legal authority regarding the interpretation of 174, and he said that no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. Or when I heard this, I knew it was going to go down. The way he emphasized it, no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. So the debate has been going on, he said, since the amendment of the Act. The initial Act was not amended in 1977. There was a prior section in 284 in the old criminal code, but what it tried is that a presumption in favor of innocence. The fact that the onus rests on the state as well as the dictates of justice, in his view, he said, will normally require an exercise of the discretion under Section 174 in favor of an accused person, where the state's case is virtually and basically non-existent. Where the evidence is dead, non-existent, which is how I feel pertaining accused number 4 is the case, that the evidence is non-existent and it's basically dead. I mean, the extraction of DNA evidence, the fact that there's nothing placing him there at the incident of the crime, it's dead, it's non-existent. But our judge found creative ways to make it exist, in my opinion. And he said that if those are the circumstances, the supplementation or the strengthening of a non-existent state case is a physical impossibility. Since the inception of our constitutional order, conflicting views arose as to whether or not the Constitution has impacted on the test to be applied by a court on its obligation in terms of Section 174. And these decisions culminated in the CSA, the Supreme Court of Appeal, finally deciding the issue in State versus Lubaqa 2001. Now, State versus Lubaqa is a case law that Advocate Nxumalo referred to in his argument. Now, this is what the conceptual enroachment of the Constitution demands. You know, in my opinion, while he was delivering this judgment, he just looked so bored at the beginning initially when he was quoting the authorities. little did I know that Haikwana Zizo Shuba, when he started expanding on the evidence. And he said, I have no doubt that an accused person, whether or not he or she is represented, is entitled to be discharged as a close of the case for the prosecution if there is no possibility of a conviction, either than if he enters the witness box and incriminates himself. The failure to discharge an accused in these circumstances, if necessary, he said in his view, is a breach of the rights of that are guaranteed by the Constitution and would ordinarily vitiate a conviction based exclusively on his cell phone and incriminatory evidence. So according to him, based on the cell phone and the incriminatory evidence, referring to Zungu's testimony mainly. And also, Umalo used this from State versus Lubakla about, I remember him arguing that because there's not much evidence against his client, he's put in a position where now he has to incriminate himself. It's almost like the state is seeking for him to incriminate himself, which is where we are headed right now since the judge decided to refuse. So now he has to take the stand.
The lifeline there to say that you are not forced to actually put your client on a stand. That's what he said. In a sense.
But what else is there? Because he's refusing with what has been presented to him.
He's basically saying debunk using other witnesses that you can get. Matidi, thank you. And Lindy Wedube, thank you very much. God bless you guys. Yes.
The
so
people that were in the house and the witnesses who came forth to testify on behalf of the state have not placed accused number 4 there. So what must happen now? Where are they supposed to get other witnesses willing to say, we did not see this man there on that night?
No, I was just answering based on that. He was basically saying that you are not forced to do that.
He's put him in a position where he is forced to go on the stand and say, I did not. I was not there. And then the state can find something they can use against him, which has been the modus operandi of this case.
Yeah, they have, where the small things such as you were not in Fosloras during that day, and then they find out you were there based on whatever that they are using. I find it funny that the judge looks at some of the things as not important when it comes to Zungu, but when it comes to the accused, when such things happen where they cannot remember, even with the situation where Zungu said he does not remember, he didn't remember some of them, he needed to be introduced. He defended him. But when the accused are doing such, it becomes an issue.
Weapon.
It becomes a weapon.
Yes.
It becomes everything that can be used in that court.
Yes.
The judge is biased, in my opinion. He is fully biased.
He finished me when he started speaking on the character of Zungu. Anyone can make such a mistake. Anyone can make that mistake except for the accused. That's what he should have said.
Yes.
Not anyone can make that mistake.
Except for the accused.
Because those kind of mistakes have been happening with the accused, because these things happened to them 5 years ago when they were arrested. They've had to recall all the way from 5 years ago on top of the trauma that they've had to endure while being accused on this case, and how they were headhunted and all of those things. And now they have to recall from 5 years ago, step by step, what had happened.
Correctly.
And then listen to the people that were arresting them deny some of the things that they have happened. And then AVL comes and proves that their version is something to hold on to.
But it's not looked at.
So he continued to say that the right to be discharged at that stage of trial does not necessarily arise, in his view, from considerations relating to the burden of proof or its concomitant. The presumption of innocence, or the right of silence, or the right not to testify, but arguably it arises from a consideration that is more of general application. So clearly a person sought not to be prosecuted in the absence of a minimum evidence on which he might be convicted, merely in the expectation that at some stage he might incriminate himself, which is, in my opinion, is exactly what he went on to do. So minimum evidence that he used to back up this judgment that he made. Some of it, honestly, in my opinion, was made up.
Yes, it was. Or it was misquoted.
Or misquoted. I don't know whether it was on purpose or what. But
a lot of it was misquoted.
If it were to be corrected, there's not much minimum evidence to hold on to. But it is what it is. So he said that is recognized by the common law principle that there should be reasonable and probable cause to believe that the accused is guilty of an offense before a prosecution is initiated in this exigency. And then he's quoted a case, Brackenstrach, Roschech, and Steenhuisen of 1951. You see, when he has to go back to 1951 to quote cases from there, you already know what that means. We've been on this journey for too long.
This is where you see that the same law does not learn. How can we use judgments that were made during apartheid in a democratic country?
And he's holding on to them for dear life when crimes against humanities were taking place in courts.
Yes, where the rights were not fully there.
They were not. When you are a person of color, you were treated very differently compared to other races. We were not considered humans.
So it surprises me that he still goes back to such and really use it as a weapon. You obviously gonna get judgments that are favoring this current situation, because if you are Uncle Tom that wants to really put black people in jail, you're probably gonna find something if you go back and read in the olden days where there was no democracy. Obvious, and you would probably know that if you are old enough to be, in my opinion, at RATHA's age.
You'd know exactly which court cases. I mean, he said he's been practicing for over 55 years. So he would know exactly which cases to use to support some of the injustices that are happening in that courtroom, in my opinion. It's strictly my opinion. And at the constitutional protection afforded to dignity and to personal freedom as espoused in the Bill of Rights seems to reinforce this version. It consequently ought not to follow that of a prosecution is not to be commenced without that minimum evidence. So should it cease when the evidence falls below the threshold?
I don't know what he is trying to explain here, because the points that he made about section 174, when can it occur, is first when if the court feels that there is basically no grounds for the state, the court initiates section 174 itself, or if there is evidence but it does not meet the minimum threshold, which is basically 40% of the evidence is there, 60% is basically relying on the defense to come with some information.
Which is the situation we're in.
Yes, so this is the situation that we're in.
Yes.
So now when you go down and listen to him talking, it does not make sense. I would have thought, in my own interpretation, that the second option is such that if the court was to dismiss such acquittal application of 174. It should be on the basis that there is, according to the court, enough evidence, not minimum. Because minimum can be interpreted in many ways.
Yes.
Minimum of the threshold that you were supposed to meet, which is not enough for you to say, let's continue with the case.
Now we continue to say so. Should it cease when the evidence falls below the threshold, and that will be preeminently bestowed where the prosecution has exhausted the evidence and a conviction is no longer possible except for self-incrimination. Consequently, a fair trial would at that stage be stopped, for it threatens thereafter to infringe on the constitutional rights protected by Section 10 and 12 of the Constitution. In application and evaluation of Section 174 of the Criminal Procedure Act, it has been held that the credibility of the state witnesses at this stage of the proceedings only plays a very limited role. It was stated in State versus Mpeta that the relevant evidence can only be ignored if it is of such poor quality that no reasonable person would possibly accept it. He wrote all of these things at the beginning, which I found very peculiar. Usually when I listen to judgments, correct me if I'm wrong, Mr. Anonymous, but you hear the authorities embedded in the evidence. It will be like authority explanation, and then, a judge helps you understand how they came to the decision that they came to.
True. To just bombard us with the references.
With theory at the beginning.
It does not help
words in English.
Analyze the situation, which is the job of the judge, to actually analyze the situation. He did not analyze the situation. He just gave the full... It's like copy and paste.
He just read it, encrypted a lot of theory and what he understands from that theory without giving us the meat. He separates the meat and calls it, this is where is the evaluation of evidence.
Yes.
But it's not linked to your authorities. So it was a very special judgment for me, in my opinion. Over these couple of years, I've listened to judgments of other judges in normal courts. You'll find that you are being, for example, we can use the Bershoff in Katiso Molefe's a denying of bail that just happened recently, a couple of days ago. I mean, you heard him explain why he was denying Katiso Molefe bail. It's a simple judgment compared perhaps to this case, but you would understand step by step as he's quoting the authorities and supporting the argument as to why he's denying him bail. I didn't get a sense of that here. It wasn't flowing, in my opinion.
No, it wasn't.
It was all over the place. I even heard some people commenting and asking, did Sibanda write this? Allegedly. Because that's usually his style of cross-examining. It's yabo.
All over.
Yeah. So in the case of S versus Adlioti 2011 by J. Como, in S versus Langengwa 1996, the view was expressed that process under Section 174 is translated into a statutorily granted capacity to part discretionarily in certain specific and limited circumstances from the usual cause to cut off the tail of a superfluous process. Such capacity does not detract from either the right to silence or protection of self-incrimination. He said if an acquittal flows at the end of the state's case, the opportunity or need to present the evidence by the defense falls away if this charge is refused. The accused still has the choice whether to testify or not, which is the part that Mr. Anonymous you were talking about.
Yes.
Now, in my opinion, by this you could already get a sense that he was not going to discharge accused number 4.
Yes.
He wanted him to be put to the stand, in my opinion. But then you're saying he was also saying they can use other witnesses to discredit.
That's what I read, in my opinion. It feels like it's saying you don't need to incriminate yourself. But you have something to answer for.
Now, he went on to say that there's no obligation on an accused person to testify. Once the court rules that there's no prima facie case against the accused, there also cannot be any negative consequences as a result of the negative accused silence in this context. He said that he agrees with the view that it is an exercise of futility to lay down rigid rules in advance for an infinite variety of factual situations which may or may not arise. It is, in his view, also an unwise to attempt to banish issues of credibility assessment and issues in terms of Section 174, or to confine judicial discretion to musts or must nots. So, in other words, he's saying he's not confining himself to strictness. When I started hearing all of this, I just, this is in my head, I'm like, oh my God, here goes. So what he's literally saying is that he's going to bend the norms.
No, what is saying, in my opinion, when he talks about the credibility of the witness, right?
Yes.
He is saying that there is no perfect witness.
He was marinating us.
Yes. He was obviously doing that, but he is saying that there's no perfect witness. A court must be able to detect and take what is right and leave what is not right. In this case, that's what he's submitting.
This is going to
now
be
the question
law.
then is a different one for me that I can ask: is he capable of doing that? Considering that he's even using wrong evidence or even sort of making up evidence, is he capable of doing that? And in my opinion, the answer is not capable at this point in time. He has not shown that I'm capable of doing that. I will take for example, when he impose on things during the cross-examination, he comes back to use them. For example, the issue of the light that went off.
Yes.
I was waiting for such, obviously, from him to use it, and he did use it. He did not go back and listen to the record, what actually happened, what was said there. What did I change?
He went on with his theory that he
exactly.
had placed
That
to
is
the
the problem
witness.
I have with him. So he's not, in my opinion, capable of being independent from the opinions that he puts during the cross-examination.
I know I was listening to that other one of 3 judges. And I heard the judges asking questions.
No, let's forget about those judges. Those judges you're talking about people who are really sober.
I heard questions.
You're talking about people who are sober,
I did not hear.
Who are handled. You can't compare those people with them at this point in time. I mean, it's a waste of time to even talk about it. I haven't finished listening to it, but there is an argument there, and there's questions that are made, and those questions, they do not mean that I'm gonna rule against you.
Yes.
But we want to go
Understand.
over and understand your submission,
argument, yes.
where your argument stems from. Don't just come with something that has flaws and you just put it to us, and because it lands and it's okay, then we're gonna make judgment on that, which is what probably would see in this high court of ours. There, we are going to argue certain points. We are going to ask you questions that are pertinent to what is you are currently submitting, and then we'll get clarity from there, so that we can make proper judgment. That's a different story. Now you have a situation where one man is a referee, where one man is a player, where one man is a prosecutor. It's everything.
He's a witness. Konke zonke bonke. He even puts evidence.
And he puts a character in these witnesses. Already, what this has helped us with, and as I said before, that this is just a taste of what to expect. And it's good that it happened now. Because this judgment does not only pertain accused number one. It actually talks about everyone else that is in that.
The
judgment.
fate that awaits all of them.
And they under the name of common purpose.
Yeah. He hammered on that common purpose. He hammered on it. Guys, this is going to be case law. There are going to be some lawyers who will be using this to justify people being imprisoned.
Let's press the like button, guys. Moriro.
I fear.
What I mean, press the like button. We are here. Amen.
I think for me, that's the most traumatic part, that there will be some lawyer out there referring to this just to keep someone in jail. Section 174 in the Senzo Meyiwa trial. Oh, Kosia.
I think there should be a system, or there should be judges who are sitting to review such.
This case needs a watching brief.
For the case such as this one, you need to review and now pronounce whether this case, upon finishing it, is it going to be good to be referenced for our courts? Because such judgments, they shouldn't actually make it, in my opinion, they shouldn't make it in court for the next or any other case that is coming.
Especially if it happens that they don't appeal. If they don't appeal, this will be case law. A bank. Well, he did say that in deciding whether an accused person is entitled to be discharged at the close of the state's case, the court may take into account the credibility of the state witness, even only to a limited extent, and where the evidence of the state witnesses is implicating the accused is of such poor quality that it cannot be relied upon or safely relied upon. And there is accordingly no credible evidence on a record upon which a court acting carefully may convict. An application for a discharge should be granted. Mina, when I hear all of this, I'm thinking, in a reasonable court. I'm thinking, maybe we have the same understanding of what this is saying, but yeah. So I had to underline this because he did the exact opposite of what the statement is saying, in my opinion. He said that in Rex versus Nganana 1948, although this comment related to the evidence of an accomplice witness, but the sentiment also applies in this case. He said he believes, but then, in my opinion, as he's saying this, did you hear that, Mr. Anonymous? The evidence of an accomplice witness. ZUNGU is not an accomplice. Unless if we miss something. Did he testify as an accomplice? Or as a witness who saw people gathered at a hostel?
I think he was referring to the evidence of the others.
To the confessions?
Yes.
Okay. Yeah, he did refer to the confessions as well. Full. He also confessed to the confessions. And he also said that a cautious court will often properly acquit in the absence of other evidence.
Now, do you hear that? In the absence of the other evidence. And I think we have went that length on that one here. In the very same, when we were clarifying this submission of 174, section 174 of criminal law. We talked about it.
We did.
Remember, we had an argument.
Yes.
What is it? What else are they relying on? And you guys were saying, no, And I was not a famous person that day, right?
Yes, we were all mad at you because you kept holding on like he was holding on right now on this church.
So let's continue.
Well, connecting the accused with the crime, but no rule of law or practice requires it to do so. What is required is that the trial of facts should warn himself, or he should be warned of the special danger of convicting on the evidence of an accomplice is not merely a witness with a possible motive to tell lies about an innocent accused, but such witness peculiarly is equipped by reason of his inside knowledge of the crime to convince the unruly that his lies are the truth. Now I was very, very under the impression that kukhulungwa ngozungula, because when I remember the law,
he was talking about the confessions.
Isn't there a law that says that those confessions are not binding to the rest of the accused? Isn't there like a law that was quoted and quoted like many times?
Again, if you guys go visit my video, some of those videos that we did when I was explaining that situation, there is such a law, but that law is not read in isolation. That law does not say, okay, if it says if there is an evidence, we are co-accused, and you happen to confess, and I don't, and there is nothing upon following that so-called confession, there is nothing that links me to you, then I must be acquitted. You must face the music. But in this case,
did that happen here?
No, this is the submission. I'm not done. Now, option number 2 is that there is such confession.
Yes.
And then upon following that confession, subsequently, we stumbled upon the gun. That Mangena would come and make it legit in court and say, this is the gun I tested. It links to accused number 5.
Accused number 3.
Number 3. So that evidence now is not it's not the only evidence. Upon following the evidence, the same confession, it was now confirmed. Sort of. I don't want to talk about this case. Let's talk about a different scenario. We kill someone. We go bury that person. You confessed that we killed someone. We buried that person, and I kept the gun. I'm not arrested. They go and find the body, and then they find the gun in my house. Now, that confession is now no longer standing alone. It comes supported by other evidence that was followed because of that confession. Therefore, on the basis of that, I can be arrested.
Did such a thing happen here and we happen to have missed it?
The gun, and I repeat, the so-called gun. Yes.
How so?
Remember accused number 3, 4, 5, apparently, according to this so-called investigator. I hate explaining this because it's just I wish you could just get it with that explanation. But the gun. So 2 accused were arrested here, were caught and were taken, and then they confessed, allegedly confessed. Well, under what circumstances it's overlooked that? It's overlooked that. Let's not even think about it now for now. And then upon that, they had therefore to take the gun because accused number 3 was already arrested and tested. Right? This is where Mangena comes in. Test the gun several times. Test it and test it. What happens? The gun confess. It's like, yeah, I'm the gun that shot Senzo. Now accused number 3 can be arrested because of common purpose. as he was explaining it, so as everyone else then therefore can be arrested.
But then common purpose does not say that if the gun belongs to someone, then it belongs to everybody. That's
what
not
it says, by the way. I think there are two cases that were read there. You are going to go to them. The one that he used today, it supports that narrative. That he even said, even when, if you conspired.
He was talking about conspiring.
Yes.
Of which there's no evidence of that conspiring, by the way. Icon.
Through the confession. They confessed, and then they followed, and there was evidence. Then from there.
Where is the conspiring in the confession?
How? Emily, what is the confession saying of accused? Let's forget about the one that is accused number one. Let's look at accused number two.
Conspiring, I guess, is planning before you go commit the crime.
Yes.
But in those confessions, where is that? That's what I'm asking. Because I heard him refer to it a lot.
What did they say? What did that confession say? What did it say?
The one of accused one was talking about Buku
No,
Telezi.
I said forget about accused number one. I know you were going to go there. Forget about it.
And then the one discredited it. How did it start? The details.
He talked about, according to that one, it was even amended, for heaven's sake, through Cronje, in my opinion. It was
Where's
added.
the conspiring? Oh, that included accused 4.
It talks about Sis Kelly, ne? It talks about Kelly being the mastermind, and it talked about them talking about what was going.
Talking to Kelly over the phone.
Yes,
at his sisters.
and what was going to happen. Tanzi being briefed what was going to happen.
Equal meeting with Kelly. In the confession of accused.
No, there's no meeting with Kelly, but there is a meeting between the ones that are in a stand according to that confession.
Is accused number 4 there?
Yes.
What was his role?
No, it's not about the role.
I mean, where was he? Where was this conspiring happening?
It's not about the role at this point in time of what the action of how it's going to happen. But accused number 2 mentions all of them. According to that confessions, right? Do you agree on that?
I agree that accused 4 was mentioned, but here's my recollection of the confession. Accused 4 is mentioned in the house, not the conspiring part. Ukhona conspiring in the confession. Maybe
how many people did accused number 2 mention?
He mentioned all of them.
All of them.
But in the act of the offense. The confession mentions them.
I think you need to, because you see, the problem is that I cannot remember vividly what.
I will need to
yeah,
go
but
that
I can tell you based on that, or you don't need a meeting, a call or whatsoever that was happening. That sort of the planning,
The planning.
Yes.
The conspiring
yes.
part in the confession of accused 2.
Yes.
I should read that confession again. So let me continue before we hammer on this and we're not really going anywhere. The special danger, he said, is not met by corroboration of the accomplice in material respects, not implicating the accused or by proof aluunde that the crime charged was committed by someone. The risk that he will be convicted will be reduced, and the most satisfactory way is that there should be corroboration implicating the accused. In the case of State versus Mahlabati, 1968, Potgieter Judge of Appeal dealt with this case as follows. It is clear from the authorities if corroboration was required, it had for the purpose of the so-called cautionary rule to be corroboration implicating the accused.
Now, do you see? Do you see where I'm coming from with the corroboration and then the evidence being found, the other evidence, therefore you get arrested because of that. It's not because of the confession per se, but because of following the confession, there was new evidence that was found. And you were associated to these people. You said you were with these people, these three people. I think is it three? No? Yes.
Implicating the accused and not merely corroboration in the material respects or respect. So, corroboration. Now I just remembered Brigadier Gininda singing corroboration throughout all of his evidence. Little did I know that there's actually a case law, a corroboration.
Yes.
What a coincidence.
It's like you is being assisted. So in a sense, what I heard from that corroboration is it must be such that the accused evidence, in a sense, is less credible compared to that collaboration and everything else that can happen there. So that whatever you say, if the judge feels that, okay, yeah, I can hear you, that situation. So you've got something to answer for. Because it feels like this evidence, according to the judge, is the top-notch evidence. It corroborated everything. So you've got something to answer because of that.
So Potgieter's view was also confirmed by Schreiner, who stated that further in the case of State versus Gentle 2005 dealt with an approach to be followed by a court when it faced with a situation where a court should caution itself in analyzing the evidence. It must be emphasized immediately that by corroboration, it is meant other evidence which supports the evidence of the complainant and which render the evidence of the accused less probable on the issue in debate.
Do you get that part? The evidence of the accused less probable. That's basically what I've just said now. Your evidence is compared to the other evidence from the state side, it seems as if the state, for now, it has an upper hand. So you need to answer because of that.
On the case of State versus Skoslony of 2008 from the Supreme Court of Appeal, the court stressed that matters which are common cause between the state and the accused cannot provide corroboration for matters in dispute. Otherwise, for example, the fact that an accused person in the, I'm going to say grape for precaution, grape case, confirmed that he has had intercourse with the complainant could be taken as corroboration of the matter's version that he has done so without consent, which would be an inexplainably absurd. So he then proceeded to analyze the evidence as well. He said that he will now analyze the evidence. Oh boy.
So
was I not ready for this?
For me, what I picked up is that the judge is evaluating in making an example of, for example, the total evidence, talking about the abstract evidence versus the total evidence, in a sense, insinuating that the defense so far has been picking and choosing what is right for them, but the judge is looking at the evidence in its entirety, which to me, when you listen to him submit all those things, it sounds like, for me, it's volume versus the total evidence, which is totally different. In that court, what I think was being submitted is volumes. He's even talking about the numbers and all that. I think you're still going there. He's even talking about the numbers of evidence that have been there, the witnesses and all that. That's volume. But does it have meat? It does not have meat, in my opinion.
You said it perfectly. He was emphasizing on how many of the evidence he was able to pick up that the defense did not even address. But here's the thing. Should Nxumalo in particular have addressed some of those things, whatever his client said would have been used against him by the state. So you are forcing him to admit to things that he is saying, I don't know any of these things. Why do you want him to comment on a confession that he claims he knows nothing about? but you want him to use the confession to debunk his case. Does it make sense? So he said that when a court refers to the evidence which has to evaluate, it means the totality of the evidence in question, not pick and choose. Like in this case, we have been sitting for about 3 years, and I'm told that about 60,000 pages of evidence so far. So when this court talks about evidence, we are talking about the composite tablets of all the evidence, because evidence is interlinked, and evidence sometimes can support other aspects of the plateau of evidence, which encompasses evidence in a trial. So what I'm also getting a sense of here is that he's literally forcing accused number 4 to say something about the confessions, to say something about the firearm, to say something about ZUNGU and what ZUNGU was saying. But saying something about those things for someone who says, I was not there, I don't know what these people are talking about, isn't that opening a room and a door for you to have things be used against you?
It has an element of that if you are going to go that route.
So why is he trying to force accused number 4 to say something about these things?
Look, I like the idea that you really preempting what might happen, but no one is forcing anyone in this case. I'm sorry, but I have to say that because you are thinking that things might go left. You know, you might use witnesses.
So you have nothing against him saying anything about the confession, saying anything about ZUNGU's testimony.
What is there to say about the confession? Why would you even put your defense around the confession?
Because the judge is stating that. Isn't that a justification of his judgment?
You misunderstood that part of the confession, what the confession did to other accused. The confession is not alone. It is now being used because it has been given the support in a sense. I don't know if you get that. I'm going to keep on hammering that so that you get it. It has been given a support. Then it is now being used. But it's not your position now to actually go straight and debunk that. All you have to do is to debunk the evidence that is making that statement or that confession to stand against you. You debunk that evidence, you are done, because then confession is left alone.
Okay, so he said that the state has preferred to charge all the accused by the invocation of common purpose. Consequently, it would be useful to grapple with what the state intends to put as a legal principle to be overcome by the accused. Common purpose, that is the act of one participant in causing of the death imputed as a matter of law to other participants, and the causal connection between the act of each participant in causing the death of the deceased, need not be proved if you invoke the concept of common purpose. What does he say?
Read that again.
I cannot.
Common purpose doesn't need to be proved.
Common purpose doesn't need to be proved.
Yes, that's what he said. There is a case that is going to use after that. I think it's S versus Fansa or something like that.
So what he's basically saying is that because the accused are charged with common purpose, there's no need for the state to prove that there is a case against accused number 4 that he needs to answer to, provided that they do not.
By virtue of being in that, that's what I was trying to explain to you earlier. By virtue of you being in that case and being charged on that purpose, on common purpose, therefore, according to this, if one of these accused have something to answer for, not even one, if all of them, cannot be that you are exonerated on the basis of, yes, you can. It can happen. It does happen. But in this case, on how they have actually structured their case around, and the other thing is that silly thing that was set by Ngumalo and accused number 4 of my whereabout links to accused number 2 accused number 5 cell phone.
Accused number 3.
That was stupid.
When did he say this? When they were presenting with
I remember he did say it in a sense that he was the one taking the pictures. I think he was tried to explain it that way. So where there was cell phone, he was there.
Well, that was not very wise, because now they grasped on it, Dagabao, and now they are hammering on it. He quoted from State versus Sefata and others from 1988, an appeal where it was stated that the principle applicable in cases of murder and its allied and other charges where there is shown to have a common purpose is that the act of one participant is causing the death of the deceased is imputed as a matter of law to other participants, provided, of course, that the necessary mesria is present.
Now, do you understand that? Is imputed, in a sense, it's transferable to
because
others,
of common purpose,
provided there is other evidence to support that.
Other evidence.
Yes, which is in this case, I think
The
they
confession.
are relying on the confession, now the gun and all these other things.
He said that the learned judges are basically saying that to make it ridiculous if you participate in the conspiracy to execute a crime, which is in pursuance of common purpose, you need not necessarily
Now,
be
that
there.
case of Fansa is contradicting the case of Mgedeza, which talks about the confession cannot stand against the other accused. That case was basically brought there to actually counter the case of Mgedeza.
How? So what happened to the case of Mgedeza?
The case of Mgedeza is basically made up of the confession of one person does not need to stand against the other person. This one takes it further to say, but if there is evidence that supports that, then it can stand.
Now, he started being aggressive, saying that he heard one of his colleagues quoting Gedeza, for instance. In Gedeza, they say you must be there, but that case of Gedeza has limitations here. They say if you are in concert with persons who planned and plotted, for instance, to murder a person by committing that offense, and if you align yourselves with that, you can be in England, for example. When they murder that person, you are also liable because you were part of the scheme.
Now, do you see? Gedeza is more broader. Gedeza does not need you to be present. In this case, the submission by the investigator is that this man was present.
In other words, accused number 4 is guilty by association.
Yes.
Okay. So also, he said that this statement by the learned judges substantiates the concept of the applicability of common purpose, and hence they allege that a causal connection between the acts of every party to the common purpose and the death of the deceased need not be proved to sustain a conviction of murder in respect of each of the participants. So you are saying that the act of...
Did you get that part?
No. I'm trying to ask.
Yeah, ask.
What is it saying?
No, you
disturbed my train of thought.
Yeah, train of thought. Yeah. So I lost that part then.
Because this is for an act of conspiring.
Yes.
And you are saying it has been proven, it's there in the confession, this conspiring part. While I was arguing that it's not, but you are saying it's there, and he's saying it's there. So...
that conspiring, it could not have been there on, maybe, let me make an example. It can be absent, but because of ZUNGU also, the meeting that ZUNGU kept on referring to, that these accused were having on the side, that also could be
but
counting.
But it did not say they were plotting to kill someone in that meeting.
Do we need to say it in this court?
Yes.
We assume in this court.
We don't have one grasp of
No, we assume in
conspiring.
this court.
I don't like this thing of speaking like these things are facts.
No, they are not facts. I'm on record in saying that they are not facts. But I think it will be dumb of us to actually ignore the fact that this is circumstantial evidence. All of it.
All of it is circumstantial evidence. Please.
So these people need to answer based on that. So if you were seen standing together, even if the person is lying that he saw you that day, then you need to answer to that.
Yeah, there's I'm hearing the emphasis on this conspiracy, and I'm like, but there's no actual thing that says there was the plotting. Did ZUNGU hear them make those arrangements of plotting and scheming to go and murder someone?
No. But ZUNGU does talk about them being together.
I can be together, but does that mean I'm talking about going to kill someone with people?
And again, I repeat, if we are not going, I'm being fair here. I'm saying
you
this
are trying
case,
to see his picture.
Yes, I'm saying this
not.
case.
I don't, because I'm like, umuntu can come and just lie on somebody.
I'm saying this case is based on that. You must understand. You must fathom that.
I can't.
And you must interpret this case.
difficulty.
You must interpret this case based on that. Because if you keep on asking for facts, you probably are going to find one thing or two. Other than that, you're not going to find anything. This case is based on assumption.
That is why I'm struggling to be on this train of all of this, all of these fallacies and hearsay, and I am having difficulty.
The hearsay part, we are far gone from that. I mean, the state has closed this case, and it has been accepted. If I might remind you how the so-called confession was accepted, but now how it is being used as a fact.
Everything is now a fact, and
yes.
I cannot ride that train. We
are not about riding it, but we are trying to make you understand, and then at the end we will tell you.
I cannot understand the understandable.
No, we are not saying understand and agree with us, but we are saying it's like how can I explain this thing? I mean, there were many occasions where when I had to look at a certain theory that I did not agree with, but I had to go and write the theory and replicate the theory and show that I'm understanding the theory. Whether I agree with it or not is another story. In this case, I do not agree with this lot of circumstantial evidence that have been submitted here. And how evidence was obtained, the so-called evidence.
Which is why I have to keep reminding and putting, I come there like the devil's advocate. I have to remind that this is what the evidence actually looks like. Because I can't. I'm having difficulty with taking the theory and running and just brushing over everything.
No, we are not running, Emil. You don't get it. Haven't you wrote any theory at school?
I have, which is why I had difficulties.
Yes.
Which is why I had difficulties.
That's why you get 50s on that module.
Yes.
Because you don't agree mostly with what they say. It's okay.
But I had to write
for you to explain it to someone else who does not understand it. If someone says, go and explain this
cram and pass and move on.
So if someone says, go and explain that thing to someone else, are you going to bring your opinion to such an extent that you confuse that person more?
I don't know.
The opinion
I would rather
clear.
not talk about it.
The
I
opinion
crammed and
is
I
clear,
passed
is
and
that
I moved on.
I do not agree also with the way this judgment was made. It just showed. But I'm happy it happened. I'm happy because I talked about it, that this judgment, even if it's one person who applied for this section 174,
yes,
it is going to give us a hint of where the judge's mind is at. Even for those who are still confused, it's going to be clear now that, okay, this biasness that we obviously, in my opinion, see in that court, it does not end there. It even creeps into judgments.
It's clear now. I hope it is clear. And please stop asking us to say, oh, but you're so hard on the judge. Please leave us alone. It's clear now. It's clear, okay? So he said that a summary of the evidence which predicates this application has been prepared by the state in response to the allegations by Mr. Nxumalo on behalf of accused number 4. He said that he's not going to dwell for too long on the history of this case. It is tried and it is well known. This application is a limited. It is not an application based on the whole evidence. It is not. And he said that when he read it, it is limited, for instance, to ZUNGU, which states that his evidence is fatally flawed, contradictory, and cannot be relied on. His evidence is as good as non-existent. That's according to Nxumalo and Nxumalo's argument. That's why he did not even acknowledge it in his Section 174 application, right? But the judge now is betting on ZUNGU, okay? We cannot also forget about how he had informed the court that he had written notes before his typed statement was typed by another person, and he said he was narrating it, that person was typing, but then it had mistakes, and after those mistakes were discovered, he said he left his notes in KZN, had to go to KZN and fetch the notes, and then when he came back on Monday, he didn't go to KZN to fetch such notes. He said, oh, I remember they got shredded in Brigadier Kininda's office. Right. This is the person that our judge is choosing to use, right, and to balance this judgment mainly on.
Because he claims that he's using the entire evidence, unlike you and your defense, who are selectively choosing whatever that suits you guys.
But choosing, that's the thing. Acknowledging ZUNGU's evidence opens up more room to say, oh, the state can go now, do parallel investigations, and then come and say, you understand what I'm saying? We've seen them do this before with accused number 1 and 2 in the trial. Within the trial, they took to the stand. And a lot of the stuff they said when they were giving their own stories were later used against them.
That's why there was a submission at the beginning that this case is not closed. The investigation continues. Do you remember that submission?
So now accused number 4, you keep saying that he's not forced to be on the stand.
No, as a defense yourself, you were supposed to be strategic on how you actually show your hand, considering the fact that they are telling you that this is an ongoing investigation while we are here in court.
And you are saying that they stand a chance of debunking what ZUNGU is saying without him standing on there.
A huge chance.
Okay.
I mean, all those accused don't need to stand there. They have said their portion. All that is left now is for Absalom ZUNGU, for example, to come and maintain the status quo, to say that of whatever that he has been making noise about on the street, in the streets here. If he's still there, if they haven't found him. Because remember, I mean, his son is a police officer.
He now said that there were 4 or 5 ballistic experts that testified. There was also cell phone evidence.
Do you see how much the ballistic issue is made of now? It's 4 people now, ballistic. 4 people.
It's 4 people. Holstein, Feintillingham, Nothing is said about that evidence. Okay, he says that Nxumalo didn't say anything about that evidence. Okay, the judge really wants him to speak on that evidence. And he said that there is also evidence that he termed it in confession evidence pertaining statements which were made by the colleagues. Why is he calling them colleagues of accused number 4?
Patronizing them.
Why are you calling them
He
colleagues?
is trying to look unbiased, that he hasn't made his mind that they are accused.
And there was pointing out of evidence, and there was a full.
They was pointing out evidence.
There was pointing out evidence, and there was a full 4 trials within a trial.
Exactly.
4. Did we have 4 trials within a trial? I only recall 1. Concerning the admissibility of that evidence, yes, I only with accused 1 and 2, yes. The pointing out of other aspects, for instance, he said that this court ruled that the aspects of evidence in this trial should be placed on record, meaning it is still up to the accused to assail that evidence if they still believe that this court misdirected itself. But that evidence still exists and it's on record.
How was it accepted? Was it, this is where it confuses me, was it for the interest of justice? Or was it accepted because it met the requirements? Because he kept on also supporting, saying that evidence can be accepted even though it was taken under coercion.
Yes.
It can be accepted for the interest of justice. Now, what confuses me and what is not clear is which stand does this confession evidence stands on? I mean, we keep on explaining it as if we are not sure where it stands in terms of how is it accepted.
Baffling. He said that, but that evidence still exists and is on record. He quoted the case of Mulimi. You know what I found also strange was that he kept looking through pages, you know. He was looking for papers. See, did you notice that, Mr. Anonymous?
No, I noticed that. He was that now is an asking issue for of unpreparedness. That you can attribute, in my opinion, to unpreparedness. Because if you had an assignment that you need to write and the pages were following each other, everything was going to be in coercion. Even how he actually made the judgment, it was all over. In a sense, it said to me that he did not write much. He did not do anything except that he knew in his head, in my opinion, that
because he's been 55 years.
Yes, he's going to decline this thing.
And also I saw him refer to the court register to give him something, you know, and to go and look for it, because this Mulimi case he was citing from the bar, you know, he couldn't quite cite it properly or what.
Exactly.
I don't know what was happening.
This is a sign that shows that he didn't write these things down.
Well, he said that I'm referring to that evidence because it's still alive and live in court and live, it's still alive and live in court, and it's still
in a sense saying that it has been accepted by the court. So you need then to debunk that. Now you know what you need to debunk. That is the first point. But unfortunately, the evidence of confession is reliant on the people that have come and went out of this case, which is Yokininde and the rest. So leave that, because you cannot debunk that anymore.
Okay. He says it has still not been analyzed in the application which has been launched by his brother, Advocate Nxumalo. He said more so, like I say, it is still live it affects certain of our accused friends and brothers here, it has not been, as the law requires, subjected to a counter application because new facts which would have come to the attention of the accused before court. He's saying, I'm saying this because it is tried that within our law, in the case of Kiev versus Attorney General of the Transvaal Krigla at the Constitutional Court, said in South Africa, in spite of the fact that we have a constitution which guarantees rights to a fair trial in terms of Section 35 of the Constitution, there remains still a tension in our law whether, even though the dictates of our law states that generally if evidence has been acquired unlawfully and constitutionally, it shouldn't form part of the legal proceedings in out country. And Krigla says because of this tension in our country that says sometimes even if evidence is acquired or collected unlawfully, it may be in the interest of justice to do that and make this evidence applicable. So instead of the investigations having started from the people that were inside the house, we have to treat this case like there were no such witnesses that have come and testified or have given the police whatever they gave them. We must rather, look the other way, as if we have no other witnesses or no other evidence except for those confessions that were taken, and the firearm that came in open seal bags and stuff. We must just take it as if we don't have any other choice.
The evidence, according to Craig, I think that we have also discussed that at some point, that some of the callers even said here that some evidence can actually be obtained illegally, but still be admissible in court for the interest of justice. I thought
that was in the interest of justice, or designed in a situation where you have no other alternatives, where you have no other things to work with, in the interest of justice. But in this situation, everything else doesn't come or feature. We are treating like nobody saw what happened, and we're just working with what we have, and we'll admit it, and it doesn't matter whether it was obtained illegally or not. We're just gonna do that.
I'm not going to rehash what I've already said about how they made that stand. Actually, I've been explaining it in terms of what process they go through to make it stand, to make it look, in my opinion, legit. The loopholes, that were sort of filled.
And then the judge said that consequently, we all know that there's a concept to say that the court may sometimes admit evidence in the interest of justice, except for the fact that it was acquired unlawfully and unconstitutionally. It was argued correctly so by accused force counsel that ZUNGU was a single witness. But then, despite the fact that the court is enjoined to examine and evaluate his evidence to see whether his evidence is a single witness, is found to be materially sound. And if that is the case, the question is, what will the court do about that? If it is found unsatisfactory in all respects, and consequently it is material. Evidence must be material in order to be sound in all material respects.
Yeah, that's basically what the judge is saying. He's saying that ZUNGU's evidence still stands. That's why I'm saying Absolution is going to play a very huge role. And if possible, even Kwabin, if they can get hold of Kwabin also can assist.
He said if you analyze ZUNGU's evidence, he says he was invited by a gentleman called Gwabeni to come to a celebration at Basotho Hostel because they will be having a party where their homeboys will be celebrating and eating and having alcohol and And, they duly arrived between 2 and 3 in that particular Saturday on the 26th of October 2014. And he says he was introduced to some of his homeboys. There were several of them there. Some he had met when he was still quartered in the rural areas, but subsequently became a policeman. He came to Joburg. He lost touch with them. And his evidence is that as a result, Gwabeni had to remind him of who was who. He was severely criticized ZUNGU for undertaking that memory trip with Gwabeni. He said, the judge himself, he doesn't find it startling to be reintroduced to a person that he last saw 10 years back. Some of them he remembers their names, some of them he did not. These are his homeboys, in my opinion.
The mixing up
homeboys
of people's names and calling other people that would later on surface in this court as people who have done something, even though they are not part of the group of 5, to the judge is nothing.
Yeah.
It doesn't seem to the judge that this person was prepared to actually come and say these things in court. It doesn't seem disingenuous. What I also find worrying is that he is then confirming himself the evidence of ZUNGU. Gwabeni has not come and said, this is indeed the truth.
Yes, what he's saying is the truth.
My uncle, yes.
Yeah, he's playing the role of Gwabeni now and affirming.
Accept this as if this is the truth. And he's basing that acceptance on the basis of what we call a picture that ZUNGU pointed as a picture of what could be. And I want you to highlight that. Could be me. He didn't say it's me. He said this could be me.
He was like, Mr. ZUNGU, that is not you. Do you guys remember?
He said it could be me. The judge is making it now a fact that the picture depicts ZUNGU.
Sure. But he said that what is critical and material for the evidence, as it will show later when other evidence is being led, is that he says evidence is that he met and saw accused 1, 2, 3, 4, and 5 and engaged them and spoke to them and even went to buy alcohol with them at Top's bottle store. This Top's bottle store situation.
And that again, how can you make that?
It's a fact now.
The truth without confirming it.
There's no one else as well who's come to affirm ZUNGU's testimony to say, yes, we were there. Yes,
that's why
this is what happened. Yes, we went to Tops on a Sunday afternoon in 2014 while Tops was not open on Sundays.
Against using single person's evidence to convict. That case was mainly looking at that because no one is corroborating that kind of confession of submission by ZUNGU.
And he speaks as if he was there. He saw everything.
The judge is corroborating it now, if you ask me, in my opinion.
Sure, it was disturbing to watch, in my opinion. Like he literally became the mouthpiece of ZUNGU. I don't know if that makes sense. Well, he said that in his view, that is material evidence, critical evidence. I left my chair in disbelief. I was like a crazy person, Gilliwan. All on my own. I'm like, what is he saying? What is this? Critical evidence. Then he said that And another thing that about this critical evidence that's shocking me, it's not evidence that has been tested yet.
No.
He's speaking as if this is the final judgment of the entire case. As the defense has not yet presented their case or the people to come and debunk or not debunk. He's speaking as if this is the final word. This is what ZUNGU is saying. And because what ZUNGU is saying has not been tested, it is truth. He chose to ignore that part, and for common purpose, he's nailing accused number 4 in these allegations that are made by ZUNGU pertaining what he claims he saw at the hostel. So not even at the scene of the crime, by the way. He did not see the crime itself. He's a witness to having seen them on the day the crime occurred. That's as far as it goes with ZUNGU's testimony. Now, because it relates to living human beings, it's not relating to a car or a bicycle, is what he said. He said that ZUNGU says he was together with all the accused and the other gentleman who's also known as Mkaya, a colleague of theirs who comes from Natal. He said, I think, Makosonke or something like that, if I'm not mistaken. He also said that he was entertained by Kwabeni. At some stage, he says that accused number 4 came to request him to move his car or somebody through the ages or through the... You know what I remember about this evidence, Mr. Anonymous?
Just say what was said.
Okay. Through the one of accused number 4, he wanted to remove his car because somebody was intending to drive out of the hostel, and he did that, and subsequently he also met accused number 4.
Now, that's butchering. I think that's what you wanted to say. That's evidence being butchered, right? The evidence that was given by ZUNGU was that at some point when they disappeared, he was asked to remove the car.
By some boy.
By somebody.
Right.
Not
a young
accused
man.
number 4.
Not accused number 4. That's what I remember.
The accused number 4 part comes after Gwabini calls Makosonke because ZUNGU's key was not available. When accused number 4 returned the key, he showed through the hands to show that you could see ukuthi umuntu okholwa kwaShembe. Because he's got afro now. You could see ukuthi umuntu okholwa kwaShembe. The way he was respectful
he
and
hasn't
say
cut his
thankful.
hair.
Yes. Now those are two different scenarios. The first scenario is when they were moving, according to ZUNGU, to commit the so-called crime. And then the other one is when it's actually a contradiction of this now that I think about it. Even the other one, it has to do with that. When they disappeared with his car, it could have been that they went with the car to commit crime.
The car whose AVLs are not available.
Exactly.
When the car was moved and now everything was now spick and span, there was relaxation, and accused 4 said this. And he said that he was clapping his hands saying, his grandfather used to do the same because he was Zulu. Nyabonga, thank you. And he says that he gave him the key. That's how close he was with him. He also says that ZUNGU said that there was, at some stage, because there's no alcohol, Jameson was finished. The guys were drinking like fish. They went to go and buy alcohol, and they partook of that alcohol. And there's a piece of evidence. He says he doesn't think that it's important, but accused number 4 bought some alcohol on the way.
He said there's evidence of the accused number of ZUNGU buying alcohol. This
Did
judge,
he?
He did say that. There's evidence of alcohol. Where is that evidence?
Where is that evidence of ZUNGU buying alcohol?
There's evidence of ZUNGU buying alcohol. Where is that evidence?
Where
Who presented that evidence? Except the word of ZUNGU.
And there's a piece of evidence, he said. There's a piece of evidence of the partaking of the alcohol that ZUNGU was a part of. And he said he doesn't think that it's important that accused number 4 bought some alcohol on that day, on the same day. Okay, no evidence whatsoever, just hearsay evidence from a witness, and now they are giving him evidence. They're saying he has evidence that he bought alcohol on that day. That we missed. We are the Dululu ones.
No, let's press the like button, guys, please. Please press the like button.
Well, the judge then said, is that corroboration or not? Because Zungu says, I bought the bottle upside down. It
so
went
Zungu's
to go.
Self-corroborating.
He said, we went to go add some more liquor. Accused number 4 was with us in that red car or white car, because he says, I'm not sure. It could have been red, it could have been white, but it's a small car. Unlike a witness who comes to court and says, we were four in a Rover, or we were in a Rover 4x4. I don't know what a Rover is. But he says that there was a small car. That's what is important, that he held on Zungu's testimony, that he said that it was a small car. And when it was pointed out to him that actually that car is in one of the photos and that it is red, then he said if he saw, it's possible. It's possible. Yes, it's possible that was the car that's in the pictures.
He forgot about the Uno.
The one in the pictures, was it an Uno? No.
He first talked about Uno though on that evidence.
Yes, he spoke about an Uno, but the red car, I remember it being testified as a Golf or something like that, or a Tez. I don't remember exactly, but I don't remember it being testified as an Uno. He says he did not particularly take care of the colors. At that time, the exigency was they were just enjoying themselves. And Zungu also says because he's a policeman, he had his service pistol in his possession, and it was a drinking spree. He had to safeguard it, and said Gwabeni had to safeguard it for him and put it in his bedroom or cupboard, and he also gave him the keys of his car. And part of his evidence said at some stage accused 1, 2, 3, 4, and 5 vanished, and he said that he became aware that they vanished when they returned in mass. They returned as a group which had vanished together. So there's nothing controversial or startling about that. Zungu says that accused number 1, 2, and 3.
Well, there is, if you are going to make a conclusion that they vanished to kill someone.
Accused number 1, 2, 3 were the initial persons who returned walking together, and they got into Gwabeni's room. And he says after some time, accused 4 and 5 followed, and they also went into Gwabeni's room. Is this proof that they were at Kutlanong Street? I'm just asking.
It has not. It has not done.
And what is peculiar and striking is that Zungu says all 5 of our friends, when they came back after having vanished for some time, he doesn't want to taper himself with time constraints, although we know that in this case, time was of the essence. He says they were obviously unsettled, shocked, and breathing hard. And what was also noticeable, one of the gentlemen, apparently he initially had a black t-shirt on, and he comes back and he had a gray t-shirt on. I heard something like hoodies. I did not hear gray t-shirts and black t-shirts and all of that. The pink in the t-shirt was changed, and Zungu, in his jovial manner, said, it appears you've got a lot of these clothing. Can you spare me some? This is what he says after he noticed that one of the accused had fresh clothing on. Zungu says that when he noticed the unsettledness of accused, or the 5 accused, he realized that there could possibly be something wrong going on, and because he had left his firearm in Gwabeni's room, he stood up and followed this gentleman into Gwabeni's room. He said that when he got in, the lights went off. It's possible that somebody could have switched off the lights.
Now it's no longer somebody switched off the lights.
Yeah.
As the judge put it. Now it's possible. That's new evidence also.
New evidence in a judgment, Mtakabao. And he said that somebody could have switched the lights off, but
from
these lights...
From light to Ishwa light to... It is possible to Ishwa light.
Hey, after some time, a minute or so, the lights were on again. At that stage, accused 2 was handing over a .38 special to Gwabeni, and number 3 was handing over a 9mm to Gwabeni. He saw that with his eyes. That's what he says. He says that shocked him because he was aware that Gwabeni is facing charges of having murdered a particular gentleman using a 9mm. Now ZUNGU is perturbed and says, "You're still messing around with firearms. What are you doing with a firearm?" It was actually a revolver. The one that they said was thrown at a river or something like that. It was a revolver.
No, it's no longer a revolver. It's a
9mm. Didn't you use it to kill Snooky? Or remember the name? Or I'll remember. He said he will just remember the name just now. He didn't even know who was being talked about. Then Gwabeni said, no. This is the one that killed RATHA or Snooky. That name is not important.
When that shooting happened is a story for another day. The judge does not look at that.
This is not the one. The one he used to kill a companion of theirs, he threw it away. So he said he examined his own firearm because he suspected that it could have been used in a manner, and he didn't want to mention this word, but that that is the evidence. He said he was aware that some people in Kabi, that's why he smelled his firearm, whether it
so
had
he was
been
also
used
aware
or not.
with these homeboys of his. They were in Kabis.
Yes.
As a policeman.
And he drank with them and drank
They were
like a
exchanging
fish.
guns, was exchanging hands.
He drank
never
with the
did
fish
anything.
like them. They got drunk like fishes together. Yes. So he said that is ZUNGU's evidence. He said he wanted to touch on some more evidence to round it up. At that time, it was a bit late. He said the party was petering to an end. ZUNGU, before he was cross-examined on this aspect, he corrected himself on the person who was making the statement because he or she had written that when he entered in Gwabeni's room, it was accused 1, 2, and 5. Thereafter, 3 and 4 followed. But he says no to the sequence. It was wrong. It was 1, 2, 3, and then 4 and 5 followed. And now he's excoriated, criticized for being untruthful. But you know what the forensic scientific result of this piece of evidence is?
We're going to a photo now.
Scientific, forensic.
That's
He said it
photo.
doesn't change the sequence of players, you know. He continued to defend him, saying that, of course, it's a mistake. I don't know if that mistake proves that he's a hopeless witness. Like I say, the 5 accused remain alive. It's different if another accused or a different person would have been put into the same aspect of. The 5 is not a fatal mistake, he said. It's not a material mistake. It's understandable. Yes, ZUNGU can make mistakes. Only him can make mistakes. And his mistakes are forgiven by the judge in the judgment. He's writing how much he understands the mistakes that he makes in his testimony. So he said that it is tried that a court sitting and hearing evidence being steeped in the atmosphere of a trial will surmise and even know and guess what is the important evidence which is being adduced. He said, like I said, an example of the fact that ZUNGU misspoke regarding the color of the car they drove to Tops. What's important about that slip is that ZUNGU on the 29th of June took photographs of accused number 1, 2, 3, 4, and 5. They told him Ngazimulo is the one who took those photos. I remember this evidence. But now we're being told ZUNGU is the one who took the photos. Am I wrong?
You are not wrong. ZUNGU is part of also these photos.
Right within the parapet of Phosphorus, this is because the pole there, the records in the record of Pinky, that photographs were taken at Phosphorus. Now he's saying that Pinky proved that the photos were taken at Phosphorus.
There is no disputing that.
Pinky ungenapi.
There
It's
is
not
no
Pinky who
disputing.
spoke on the photos per se.
There is no disputing of the connection of the phone. But at what time did that happen?
Do the photos have the the time in which they were taken.
At what time did did Pinky pick them at Phosphorus? Did he pick them at 8?
On the photos. We're talking about the photos.
I know it was not. It was not picked at 8. They did admit the accused number 1 and 2, 3 that
we did go to Phosphorus during the day.
Yes.
Then we went back to Johannesburg. Even the cell phone records that Pinky Faintilengem was going through show such a movement that they did go to Phosphorus, but then they went back to Johannesburg. By around 8 o'clock, it was pinging somewhere in CBD.
Exactly.
So he's ignoring all of that. To such an
extent that he had to argue that the phone could have went to Joburg on its own.
Yes.
The judge.
Yes.
That is.
So it means he believes this fallacy that he is in his head. He's believing it and he's choosing to rather believe it. This judgment is saying that because when he puts them, it's almost like it's something he's suggesting. But no, it's something that he's making up as a fact in his head. I hope you guys can see that. So accused number 4 concedes. He said, I don't know why he had to do it. He says his client aligns himself with the evidence regarding the direction of accused number 5. Accused number 5. Did he say that? Wasn't it accused number 3 that he said he's aligning himself with?
I think it was accused number 3 because that's what I wanted to ask. The phone records that are available, aren't those phone records for accused number 3 only?
It's for accused number 3 only from 2014. Yana is busy bringing in accused number 5. Hey, Batumba team. Hey. When I tell you that this was a mess of a judgment, he asked Baloyi what he said. Baloyi said he aligns himself with the cell phone records of accused number 3. He then said, I'm not supposed to ask you. Then he says that he aligns himself with the cell phone path of some of his colleagues. But the point he's trying to make is that there were photographs taken. Exhibit S. ZUNGU himself said he was taken a photograph. There was debate between himself and Mr. Mnisi to say, this is not you. Then he said, it's me. I know myself. I remember that part. He said, ZUNGU, this is not you, say. He misconstrued some of the person's faces there. But what is important is that photographs were taken on the same day, during the same day, the same spell of time by Pinky. This is not true.
But even if the what we call the aerials or whatever that you may call it, those things are reading them, at what time is it pinging on those towers? At what time? Does that then say at around that time this is what happened? Number 2, does this for accused number 3, according to the so-called confession of accused number 2, spoke to Kelly? Is there a connection there of Kelly with accused number 3? No. Did that cell phone of accused number 3 ping closer to Kelly's phone when they were entering the house? No. If we were to use the towers, basically the evidence is just messed up. It's only a judge that does not listen, only a judge that is brought as a gun to actually convict these people so that we can keep quiet, can really think otherwise. The so-called evidence that is looking at is immaterial, according to me. And the material evidence that is very crucial, like the time, is the cell phone of accused number 3 that we will like to get the section 205 of. Is it getting closer? Because even in that confession, it is said that he was talking to Kelly.
Yes.
Did it have a link with Kelly? No. So that is not crucial evidence according to this judge. But what is important according to this judge is that someone pointed at whoever that was in the picture, who probably does not even look like him, as him. And he takes that as the truth.
And another disturbing thing is that he's speaking as if that photographs have timestamps, and the timestamps correlates with the cell phone evidence. That to me was the disturbing part. For someone who claims to understand evidence and listen, I'm very, very shocked. And also, usually I'd hear people saying that this is bad luck. But I'm realizing that when people want to nail you, they don't even need evidence against you. That's what I'm realizing.
Let's press the like button. Let's finish up, Emily.
Okay, so it is not corroboration that ZUNGU is supposed to not have been there. It was put by various counsel here that you were never at Basutung Hostel and you also never met at Basutung Hostel, but apparently there are photographs. Some of these pieces of evidence, for instance, it is important also this S4, which allegedly was robbed out of the house of Kelly and her mom, Zandi, said that one of the accused, he said it's accused number 4, and he said whatever, I don't want to mention the name because that has not been settled, right? From what I remember on Zandi's evidence, she said it's accused number 3 who came back and elbowed her mother. But the judge is saying he doesn't want to mention who it was after saying it was accused number 4 who elbowed Kelly's mom. And then he comes back and says, I don't want to mention who it was. Then he took that cell phone, and that cell phone was subsequently found in the late evenings. Was that cell phone found? As far as I know, that cell phone was not found.
Oh, it was not found.
It was about 463 meters away from Basutung Hostel in the opposite
Through
direction.
the tower pinging. So now, a tower can actually give you your exact location.
According to him. The evidence which is not being contested here is that after Senzo was murdered, everybody panicked. How do you know it's everybody who panicked? Because not everybody who was in the house and around the vicinity of the incident taking place has come to court to testify. If you had said, according to Zandi, everybody panicked, it would make sense. But you are saying everybody panicked as if you were there. Senzo was taken to the to the hospital. My apologies. Unfortunately, he lost his life there, and the police subsequently returned on the 26th in the evening. And on the 27th, they are busy with investigations. But what is telling is that all people who were in the house, their cell phones were taken and they were downloaded. And there's proof, without doubt, that all the cell phones gravitated after Senzo was shot towards Bupilong Hospital. And when they came back, all of them were taken, obviously, but they first gravitated to the hospital. But no cell phone of Miss Kelly Kumalo went to the hospital because somebody took it and went the opposite way. That is where it was deactivated to show that it's a trip.
And it was stolen. So, because of that, it's a proof that it was stolen.
It was only a way, and that shows forensically, according to the experts, that the cell phone was actually robbed. Concerning cell phone records and utilization of these cell phones are attributable to the gentleman in front of us, referring to the accused. And that signal which was activated was in the vicinity of Basutung.
Now, the evidence of being said, depending on the connectivity, the phone will hop around the areas that are there. According to the judge, it is fixed that if I'm where I am, I'm bound to connect to whatever that is closer to me.
Yeah.
Whether it's overloaded or not, it
doesn't matter. He said, we all saw the map, we have to revisit it. How far the so-called crime scene is, how far Basutung Hostel is. Pinky actually made a remark that maybe if you go there using skates, you'll reach. That's how near it is. And a cell phone, technologically, it zooms in for effective usage on the pole, which is nearest to it. It's a tower, Judge. It's a tower. It's not a pole. The nearest pole, he kept referring to, the nearest tower was there. poll of phosphorus, and we can count the telephone calls, which we all know them. There was communication of accused 1, 2, 3, 4, and 5, and vice versa, and everybody was using a cell phone. This is pertaining calls. Remember that the only evidence or cell phone evidence we have is that of accused number 3 from 2014.
Yes.
Everybody else, kalang with 2018.
But all of a sudden now there are people, the judge is saying all the cell phones.
They were communicating. The accused were communicating.
The
This is new
that
evidence.
Sibanda was giving of them talking while they were in jail is now the evidence that happened in 2014.
Yeah.
If the judge is not confused, I don't know.
Using a cell phone at or near or after Senzo was long killed, the phone's communication continued. So he's also implying that the accused communicated with each other via cell phone in 2014 and long after, even though there's no evidence backing up this claim from Pinky Fine-Telengam. It's new evidence that
While they were in their
communicated
house, they were still
2014.
communicating a cell phone. While they were in the same house.
And then he said that Advocate Ngumalo says in his heads of argument that the evidence of ZUNGU is marred by material contradictions and affects his credibility. Assuming he's correct, it therefore means his evidence amounts to nothing. He says that there were photographs to the effect of going to Basutung hostel evidence, even though the accused say it was George Koch hostel where the photos
How
were
can you
taken in
debunk that?
2018.
How can you debunk that?
He doesn't care. He will take Zungu's testimony. Yes. And he's doing this
Even if the person who's in the photo can come.
even if a person who's on... we'll see. The defense has to call everybody in that photo now. What can they do? To say, this is George Koch hostel. They must. What else can they do? What's him? So that evidence has corroboration according to the judge. He said Mr. Ramasipili, when he was cross-examining ZUNGU, he put it to ZUNGU that my client, accused number 2 himself, says he does not know you in total. He just saw you there yesterday in court. Later on, of course, he corrected himself because there were photographs which depicted ZUNGU and some of our colleagues in court.
Portraying accused number 2 as a liar.
But when did this happen? I missed it. When did accused number 2 say in the photos there ZUNGU was there? When did that happen? Guys, ibangati we are watching 2 different cases. Did that happen?
So
did
it seems
accused
as
number
if
2 point
it's
ZUNGU
no,
in the pictures?
No, he didn't.
Yo, this is disturbing. He now partook as ZUNGU's character witness to say that ZUNGU was very satiric when he gave his evidence. If you read him clearly, he was saying this with so much attitude, and it felt like he's a prosecutor or he's ZUNGU's defense counsel. It's like ZUNGU's character now. He's speaking on ZUNGU's character, as if he knows him. Has consulted with him. He even said that some of us didn't pick it up, but he picked it up. He said that ZUNGU would answer, I thought if you are saying that, I would be lying. That's how he used to answer some of the questions. I can quote them for you. He was using a lot of satire. For instance, here is a satire that I picked up. When Mr. Ramasipili had said to him, my client does not know you in total. He just saw you yesterday here in court. And ZUNGU said, if that was said or was coming from accused 3, 4, and 5, I would have agreed with you. Okay, where I was born, it's in Ntanzi. So the judge said that that's pure satire. But if you don't understand the way he plays the language, you cannot pick it up. He's educating Nguni people, Nguni legal counsel. Umnisi is Swati, he said. Umumalo umzulu. Umshololo umzulu. And he's educating them about their language. Tata wena judge. Some of the persons who were in the photograph, hi khona hi ngiyamvuma. He said he could not identify them because he says it was for the first time that he sees these persons. And I say we shouldn't forget that there was other evidence, also ballistic evidence, which Mangani testified there too. So Mangena says that the firearm had been identified beyond all doubt. Ballistics says no two firearms are the same in the attraction, the rifling inside, even the bullets, the way they penetrate the matter.
Nice argument. Balo just gonna copy and paste.
When Mangena said this firearm is the firearm that was used to shoot and kill Senzo Meyiwa, we don't have dissenting evidence before us because we are still dealing with a section 174. And we all know that confessions cannot be used against another unless there are other elements of facts. Section 218, he asked Baloi to find it for him so that he can read it. And then he said, Gininda says he's one who arranged for the taking down of the confessions of accused 1 and 2, including the pointings out of accused number 1. And in terms of section 218, Gininda was able to read the confessions of accused 1 and 2. And as a result of that, he got information through reading those confessions that this was a planned hit. It was not a robbery gone wrong. He's not disbarred from having access to those confessions. The fact that he's an investigating officer is neither here nor there. He got information through reading those confessions that this was a planned, premeditated hit. It was not a robbery gone wrong. These confessions were taken when in 2020, and here he was talking Nabo Zungu in 2018, Nabo Absalom Zungu before taking Zungu's statement in 2023. Yeah. He did not know about that. He could not have done it and he didn't do it. And then he said that Zungu's evidence is not a total write-off. We have taken 2 hours talking about it. If it was a write-off, I'm sure we would have taken 15 minutes. More than 2 hours examining Zungu's evidence. I beg to differ. Advocate, when you say there is nothing that can be leaned on from there. For instance, Zungu is the one who introduced Gininda to his father, who lives in Durban and runs a taxi between Mpumalanga and Natal. Konjo uZungu toba wakhe.
New driver, new evidence.
He's a driver, not even an owner, a taxi driver.
Did he say that?
I don't know.
I
don't remember.
Icon.
This is new evidence from Mpumalanga to Natal.
Let's conclude, man.
He said that it's hearsay evidence, but it's fine. Who hears that there are persons who are responsible for having murdered Senzo in Durban, Peter Maritzburg? He was flighted away towards Joburg by Gininda, who took a statement from this unreliable informer called Zungu. He gave Gininda the information. Of course, Absalom Zungu disputed all of this in the Daily Sun interview that he did. He even went to Newcastle police station to make a statement to that effect. Hopefully the defense will get a hold of it. Even if it admits that Zungu's, is unreliable. I don't know whether it was an admission or what, or he was just hinting, or I don't know what is going on with this judgment. So he said he begs to differ with Advocate Nxumalo that the evidence of Zungu is unreliable, contradictory, hopeless. Nobody can make the head or tail of that evidence. That evidence, like in State versus Gentle, had some corroboration. Tata corroboration. For instance, that he was there at Basutung Hostel. All indications are that he was there, because if you are saying he was not there, how would he know about tops? How would he go and take photographs with colleagues there? Again, this is new evidence. Zungu took photographs with the accused. And then he said, no one says Zungu is a perfect witness. I've never come across a perfect witness in 55 years in the profession. For example, he says that when they were jolling happy on the 26th of June 2014, accused one celebrated and said, have you heard? 26th of June 2014. Can't poor judge. Then more. It startled him. He checked his social media, SIM card or phone and asked him not to joke like that. He got the shock of his life when he heard in the morning that Senzo Meyiwa had died. He then went to buy a newspaper and there it was, confirmed. Nobody knew the previous night. So he said this is an application to establish if there's evidence, not Zungu's evidence, if there is evidence. Firearm, bullets, cell phone which was robbed, if there's also evidence of telephone calls exchanged. We are not about the merits. It was not to see if there was evidence upon which a reasonable man thinking seriously can convict, but I don't even put it that way. At the most here, I find that there's prima facie evidence that needs an answer, and there is, and I don't have to delve into those other aspects, and consequently I cannot discharge accused number 4. He said that there's evidence which is reasonable and he has to discharge or confront it. So he's literally saying that he has to confront evidence that, in my opinion, but Mr. Anonymous, you don't want to hear it. I'm done. Yeah, that's it, guys. That was the judgment.
No, I see. Thank you, Emil. I think it's been 2 hours. Did you notice we have been going? Yeah, let us give it time for tomorrow. For tomorrow, ne?
Okay, and they are coming back on the 22nd. Nisi asked for more time to consult with the witnesses. They are cross-province. Some of them he's going to have to travel to KZN, travel to different provinces. So he asked for more time and Mishololo recommended until the 22nd. Of course, 22nd was supposed to be recess, but then Advocate Baloyi said he will make arrangements. They, as the state, have no problem with resuming.
I have a problem with the strategy of the defense. Also, when it comes to Mnis, Mnis is a perfectionist. Mnis wants to prepare all these people properly and have them lined up. No, don't do that. You're wasting your time, because what is going to happen is that eventually some demigod will reach these people. Stop trying. 22, start with the first witness. Don't tell me about, you are going to... No. Start with the first... This is thinking is the people here who are playing a fake game here. This is not a fake game.
It's not.
I don't understand him sometimes when it comes to these things. Why are you dragging? Don't drag. You are capable of attacking. Trust your people. Just need to have a few conversations and trust them. Gamble if you have to gamble. Press the like button, guys, please. I'm looking at your comments here. But we will attend to them tomorrow, guys. Please, for now, I think it's fair for us. We've been sitting here for 2 hours, more than 2 hours actually, for us, before we even started delivering this evidence to you guys. Even Emily voice is tired, isn't it? We are tired. Right. Thank you all for being here. God bless those who gave. God bless those who joined as membership. And God bless those who subscribe.
Okay, tomorrow prepare your notes. Siyawatetela ma-call.
Tomorrow
it's only calls. I don't think I'll even prepare anything.
Kuningi wena email or khona yabona nje manje kumele so prepare something else, but prepare your notes. Stetela ma call tomorrow.
Yazi ngifuna ukubhodla ngicela nizeni. Please come, please show up.
Let's
10
press the like
o'clock,
button.
10 p.m.
Let us
tomorrow,
sleep on
same
500 today. Let's sleep on 500. This was hell of a judgment, which is and before I say things, guys, thank you very much. Let's end it here.